Welcome to this presentation. Today we're going to cover how to write a legal memorandum. So let's get started. There you go. So I'm going to go down to the module that's focused on legal memoranda. And we're going to start by looking at the PowerPoint slide. We're going to focus on this first button, PowerPoint on effective legal memoranda writing, and also on this article on writing the memo. But let's get started with the PowerPoint. So why do we decide, or why does somebody in our office decide that we need a legal memorandum regarding something? Well, one of the first and most important things to know about legal memorandum is that it's not a scholarly undertaking. It is designed for a very practical purpose because, after all, it's probably going to cost the client a significant amount of money. And so the client isn't going to want to get a legal memorandum unless he or she sees a real benefit to him or her in having this work product. Think about it. You're going to be spending probably a matter of several hours reviewing it. An attorney is going to have to be involved at least in the initial stages of defining the issue and reviewing it, and then probably communicating it to the client. And so there's going to be some time with the attorney as well. It's hard to imagine much in the way of a legal memorandum not costing at least $1,000. And so it's a significant investment. Obviously, if it's done by an individual, it's a pretty big amount of money that the person is going to be thinking about. If it's a corporation, it may be less of a big deal, but still, at the end of the day, the corporation is going to come back and say, now, why did we need this? Or what did I get out of this to help me, or to help me make a decision about something? So it's designed to be problem solving. We figured out a problem, and now we're trying to figure out, or we think we have a problem. Maybe it actually ends up not being a problem, but we are at least wanting to investigate a particular issue to see if it's a problem, and if it is a problem, how we're going to solve it. It is going to involve objective writing. We aren't going to be involved in persuasive writing. We aren't trying to persuade anyone of anything except what we have learned in terms of our research. This is something that is just shared within the law firm and possibly with the client. It's not going to go to the court. It's not going to go to opposing counsel. It is something to be shared within the legal team. And so the goal is to be objective in the writing style. There's going to be some facts that support the position that you ultimately take, or there'll be some facts that oppose it. There'll be some cases or some statutes that support whatever you decide is the correct answer, and some that oppose it. You come into a legal memorandum really being indifferent as to whether you're going to find A result or B result. That can be difficult to do because usually your client is very interested in you finding answer A or maybe finding answer B. And so there's a temptation when you prepare a legal memorandum to approach it from the perspective of, wow, my client really wants the answer to be A, so let's try our hardest to see if that's what we can find out to be the case. But of course, you're really not helping your client when you do that, because the answer is what the answer is. And if the answer really isn't A, it's certainly not a good idea to tell the client the answer is A. That actually puts the client in a worse position, because if he knew the answer wasn't A, yes, he or she might be disappointed, but at least he or she's in a position to make wise choices based upon that less than advantageous news. So you want to go into it not having a particular agenda, and you want to write in an objective way. We're going to talk about how it's necessary that you take a position, but you don't have to overcommit to a position. You don't have to say, oh, it's for certain that this is the answer. You can hedge a bit, and sometimes that's absolutely appropriate to do that. So you might say probably instead of definitely, or something along those lines. And you'll definitely want to present the evidence that might conflict in some way with your answer. And you're not presenting it so you can shoot it down, although if there are ways that you can minimize it or shoot it down that are legitimate, then of course you want to do that. But no, you're doing it to show the complexity of the issue. And sometimes these issues are really, really complex. And so it's perfectly reasonable for you to say, these are all the reasons why I think the answer is A, but I need to also tell you the reasons that would make another person perhaps think the answer is B. So think about it from those perspectives. Now, as we've been talking about this, some of y'all may be thinking to yourself, is it really appropriate for a paralegal to be writing a legal memorandum? Because it sounds very much like the person who prepares a legal memorandum is preparing legal advice. Well, if you've spotted that issue, you are a very, very savvy person. You have figured out that, in fact, in order to write a legal memorandum, pretty much by definition, you have to give legal advice. And if you've taken very many paralegal courses at all, you've heard several times that a paralegal cannot give legal advice. In fact, the only people who can give legal advice are attorneys who are admitted to practice in that particular state. So you may be thinking, well, why are we learning about legal memorandum if we're never going to produce a legal memorandum? Well, let me pause for a second and talk about kind of the frequency idea. There are paralegals who never produce legal memorandum, either because of the nature of their practice or because they haven't demonstrated to their attorney that they have the skill set that would make them an effective legal memorandum writer. Writing an effective legal memorandum is a very high-level skill. You can have a rewarding, exciting career and never reach that level of proficiency and still be a successful paralegal. But certainly those of us who do reach that level will find that there are advantages to that. Number one, writing a legal memorandum is intellectually interesting. It can make your practice something that you find rewarding on a new level. It also probably indicates that you are very, very respected in your office, which of course is satisfying. And hopefully it also means that you're being financially compensated at a level to reflect these very sophisticated skills that you have. So at the end, if you think to yourself, gee whiz, I just don't want to work that hard to develop these skills, it doesn't mean you can't be a successful paralegal. It just means that you're limiting, kind of your upside prospects, which is perfectly valid. And I'll be honest with you, most paralegals who are straight out of paralegal school aren't ready to write legal memoranda, in part because they are still fine-tuning their legal writing skills and their legal analysis skills. It's also probably true that they aren't the best candidates to write a legal memorandum at first because their knowledge level of their particular practice area is not very deep. So for most cases, we're probably talking about something that you might be doing 3 to 5 years out in your career. Don't mean to say that's always going to be the case, but that might be the case more often than not. But if you decide that you want to develop these skills and you end up in a practice where it's a good fit, this can become a significant portion of your practice, and it can be very, very rewarding. Also, if you're thinking about law school, obviously legal memorandum is a very, very, very big part of what many junior attorneys do. It's really kind of where you prove your mettle in many law firms. So we've kind of introduced the concept to you. Let's go forward and talk about the formatting of a legal memorandum. Many law firms have what are called style books or style guides. And these are manuals that tell the people who are producing the documents, be they a word processor or a secretary or a paralegal or an attorney, how documents in this law firm ought to be prepared. And some of the answers to this question are going to vary significantly from one law firm to another. A style book will talk about things like fonts and margins and things like that. Since this is a document that isn't ever going to be filed with a court, you don't have to worry about following any kind of local rules or any local practices that might apply in your jurisdiction if you were filing this document in court. So you really have a lot of flexibility to follow the style book in your particular firm if something like that exists. I'm going to give you an overview of a really common format, but of course where you go to work you may find that the format is different. Obviously into those situations you'll want to follow the format of your particular law firm, but I think you'll find in most cases that what we talk about is pretty easy to transition over into the other format. If you work for a smaller law firm, you may well find that there is no style book for legal memoranda, at least. Probably there is for a letter, but maybe not for a legal memoranda. And so you can adapt for a style that you think makes sense. You may want to consider some aspects of the style that I'm presenting as an effective way of presenting it. You may also want to tweak it and use a style that you see elsewhere. Some firms, especially smaller firms, aren't going to have a formal style book, and so it's a good idea to look at what some more senior individuals in the office routinely do in terms of documents. For example, it might be a good idea to touch base with the secretary who supports the one of the named partners, to see how he or she prepares documents for that attorney. You may also want to deal with a senior paralegal to see kind of how his or her documents look. You may not feel like you absolutely have to follow everything, but it's probably a good idea to follow most of what they do, especially if those two people are doing the same things. Some law firms, it's very, very lockstep, and if you vary it, it's not going to be a very good decision for you. Other firms are more flexible on those issues. But still, the formatting of a legal document is probably not where you want to devote your energy to step apart from your colleagues. So you want really the content to sing, not so much the formatting that you use. We're going to talk about having 6 portions of your document. And of course, the first one is going to be your heading. That's how you communicate who you are, who you're sending it to, who this is for the benefit of, the client matter identifier, what is the question or questions that you're actually going to be presenting, and what is the date of the memo. You're also, this won't necessarily fit on the heading, you'll probably put this in a footer, but you'll also want to identify things like attorney-client communication or things like that. Because after all, this is a document for your client to be used within the law firm. It isn't going out to opposing counsel. Even if you write it and you think, oh my gosh, this is going to persuade opposing counsel that this is exactly what's going to happen and it's going to be really, really good for our client. Even in that situation, it's very, very likely that the attorney will draft it so it's in persuasive format, not an objective format. The attorney might use 90% of what you've done, but certainly would make some tweaks at least. So what you're preparing won't probably ever leave the law firm, and if it does leave the law firm, it will just go to the client or other people kind of within that circle of trust. So the heading is the first thing. The next thing is going to be the statement of facts. This is going to be your opportunity to explain what happened in the particular case. We'll talk more, of course, about all these categories going forward. And then we'll have questions presented. This is the opportunity to define the particular issues that you've been asked to look into. And we'll talk about that going forward too. Many times the attorney will actually give you the questions presented, or at least the concepts. You may need to tweak it a little bit so it fits into the format, but usually you'll have a fairly good idea of what that's going to be. If you don't, and you're really kind of struggling to come up with it, I encourage you, once you've come up with some ideas about it, to email those back to the attorney to just do a double check to make sure you're on the same page that he or she is on. Then you're going to present answers presented, and these are going to be brief because this is going to be a brief summary of what you're going to talk about here. Some people kind of consider this the executive summary portion. This is almost, if you imagine a murder mystery novel, this is the whodunit section. This is for people to read who just want the quick answer of, oh yeah, that's the answer to the question. And sometimes that's all the person really wants, is just to know the answer. At other times, though, people aren't so focused on the answer, but they want to see how you got there. They want to understand the deeper issues. For one thing, they may want to make sure that they agree with your analysis. And what better way to figure that out than to actually go through your reading? And that way they can read the cases you reference and read the statutes and regulations that you reference. And they can see if there's gaps or issues that you haven't explored. And they might also be able to see how one issue leads to another and how it might lead to other areas that you haven't gone into. So many times the answers presented is important, but really the analysis is what the reader is most interested in. And then we're likely to have a conclusion. You may say, well, what does the conclusion get you that answers presented doesn't get you? And many times, especially if the writer of the memo isn't very expert in this area, many times it won't really get you a lot more. It's just kind of a repetition of the answers presented. But usually you're trying to come up with some development from the answers presented, and also sometimes kind of a next steps. What are we going to do with this information now that we have it? Okay, so here we go. True, false. Legal memoranda are usually shared with opposing counsel. My guess is you know the answer here, but just a little reminder, that's false. Legal memorandum usually have some statement like attorney-client communication. That is true. Actually, we'll usually say attorney-client and or attorney work product communication. You want to mention work product, especially since you're the paralegal and therefore you're neither the attorney nor the client. So whatever you produce won't be communicated directly to the client, and you aren't the attorney. So your work is called attorney work product, and so you would want to include attorney-client communication and attorney work product. So this isn't completely true, but I was trying to flag this issue of that you want to communicate that this is a privileged document. Let's pause for a second and talk about why that's an important idea. Let's imagine that we're in the throes of discovery and it's a big case and we're going to have to produce lots and lots of documents. That can be a very daunting, very expensive undertaking. And sometimes, usually it falls on the paralegals to do that. And, you know, human error happens. None of us are perfect. And certainly if you're doing a huge document production, it is easy to miss something. You know, you may be working 8 or 10 or 14 hours a day going through page by page by page. It's easy for you to have a little mental hiccup and miss something or not be focused to the extent that would be ideal. And so something like that legal memorandum you might inadvertently produce. Well, first of all, if you have something like attorney-client work product on it, that means probably it's less likely that you will inadvertently put it in the document stack of the documents they're supposed to be shared with opposing counsel. So that's one purpose. It can help you avoid the mistake. But the second purpose is that if you accidentally do produce it to the other side, then the fact that you've included that language in the document makes it more likely that the other side will have to force to give it back up to you. Another thing that can be helpful about the statement is that sometimes there's a dispute. Sometimes your client's position may be, that's privileged. We don't have to share that with the other side. But the other side's position might be, well, no, you have to share that. We don't think that falls into the attorney work product category. And ultimately, the court is likely to do an in-camera review. Now, when I say in-camera, I don't mean a camera like takes pictures. In Latin, the term camera means room. I think that goes back to the fact that the first types of cameras back, say, in the 1800s, were really almost mini rooms. You may have seen pictures of old-timey photographers who would have this like black almost drapery over them as they took the picture, and they literally were in a maybe 1 or 2 foot by 2 foot little space where they could you know, kind of see what was going on in the lens, but they were almost in like a room. And so that's where the history of the term is. So when we say in camera, we mean that the judge will review the document in his chambers, and the judge will make a decision whether the attorney-client privilege applies or not. Now, putting the language attorney-client privilege and or attorney work product isn't magic pixie dust. If it isn't attorney work product, putting the words attorney work product on it is not going to persuade the judge. But I will tell you that it is one of the facts that the court will consider. And so if the court is on the bubble, not sure if if the judge is going to prohibit this document from being shared or not, having that language could be the tiebreaker. And so those are the reasons that we want to include that language in a legal memorandum. Okay, so the answer is yes, but you're going to write it better than this. You're going to say attorney-client communication and or attorney work product. And now we have legal memoranda are examples of objective writing. Let me pause here and just talk about this. When we have the UM ending, that's singular, and we have the A ending, that's plural. That's the way that most neuter nouns in Latin are made plural, by taking the UM off and adding A. In English, we can say legal memoranda for the plural form, or we can say legal memorandums for the plural form. Either one is correct. You'll probably hear that legal memoranda is more common, especially in written form. I think a lot of legal professionals would kind of wince a little bit if they were to see legal memorandums. So I don't encourage you to write it that way, even though you would not be incorrect to do so. So let's go back here. Legal memoranda, plural word here, are examples of objective writing. That is true. They should never be written in a persuasive writing format. Finally, effective legal memoranda are practical and action-oriented. Boy, this is true, and please don't ever get into a situation where you think you're answering philosophical questions or kind of, oh, that'd be nice to know type of questions. You'd have to have a very, very wealthy client to be given the luxury of doing those types of tasks. If you aren't sure what the client needs and how this is going to advance the client's interests, that probably means that some of the part of the equation is missing for you, and you probably ought to get back with the attorney to make sure you know exactly what you're supposed to be doing. Okay, so here is our heading. Couple things immediately occur to me about this heading is, oh my goodness, they used a sans serif font. We want to use Times New Roman. That's an excellent font. You also have Garamond. There's other fonts that are good, but you want to have one with serifs. And again, we can look up here if you aren't sure what a serif is. Look at this T here. You can see it's got little marks on the sides at the top and then a little feet at the bottom. And you can see on the H, there's a little flag here and there's little feet here. All of those are called serifs. You can see here, though, on this M, there are no serifs. On this M, there's lots of serifs. For legal writing, you're going to want to use a serif font. Now, of course, if your particular firm, for whatever reason, chooses a sans serif or a font without serifs, then that's what you ought to use. But the majority of firms, probably the vast majority, are going to use a Times New Roman. And it's considered more elegant. It's considered easier to read. And of course, you'll want to follow whatever the local rules are if you're filing something with court. But again, this isn't something that's going to be filed with court. If you don't have a style format, then this is again an area that you'd want to touch base with 2 or 3 or other legal professionals who routinely prepare documents in your law firm. And again, if you don't see a trend, I would encourage you to pick a sans serif. Nobody is going to be offended by using Times New Roman. It's not the most beautiful font, but it is very serviceable and it's very well received. Now, of course, you're not going to use that if your firm has a designated font that's different, but that's one to think about. So when you look at this document, the first thing that many legal professionals will see is, oh, what a terrible font choice. So don't make that choice unless your particular firm thinks this is a good font choice. Next thing is how the order of these items are. This is kind of an unusual order. In my experience, the date is usually going to be right above the ray line. So we'll start with the to, then we'll have the from, then we'll have the date, and then we'll have the ray line. So let's talk about to. This is who you are writing the letter to. Obviously, since you're going to be providing legal advice here, you're not going to write it to the client. You're going to write it to an attorney. In this case, we have his full name, Alan P. Gilmore. Now, in this particular example, they've designated his title. He's a partner in the firm. Some law firms, that would be common to designate. Some law firms would just end it with Gilmore. So either way, it kind of works out. This is kind of a formal document, so maybe Alan P. Gilmore goes by Al around the office. And Al's fine to use if that's what he prefers, and certainly there are people who would like it to be more informal. What you may want to do is just see, how does he have his name written below his signature when he signs letters? He might have Alan P. Gilmore written, and then he might sign it Al Gilmore. So the thing you'd want to match is what his secretary types below his name. If the secretary types out Alan P. Gilmore, then that would be my recommendation for what to put here. If the secretary types out Al Gilmore, that's probably what I would use here. I don't want to act like it's a huge issue. You don't feel like you have to become a detective to figure out all those details. But if you're not sure, go ahead with the more formal version. And oftentimes people will put their middle initials in. Obviously, if there's more than one Alan Gilmore, it's a no-brainer to put the middle initial in. But even if there is just one Alan Gilmore, you're going to, in most cases, put the middle initial unless you have some reason to think the person would prefer not to have his middle initial in here. And then from, and again, you're probably going to use a similar rule. Whatever you would sign or put below your signature is the name that you're going to use here. So maybe with the middle initial, maybe not. Then after your name, you're going to put a comma, and then you're going to put paralegal if that's the title that you go by in your law office. Of course, if it's legal assistant, you'll put that. You'll need to have some designation here, though, that communicates that you are not a licensed attorney. So again, that designation might vary. You may say, well, why is that important? After all, we're not sharing this with the client. Well, the reason that it's important is several-fold. Let's say that you go on to law school, and so you go back to join this firm 5 years later. Well, people may no longer remember that when you prepared this memorandum, that you weren't a licensed attorney yet. And so when they stumble across this memorandum, they may assume that it's prepared by an attorney and therefore not really feel the need to kind of double check the information to the extent they would if a paralegal had prepared it. Or perhaps you never go to law school, but you go on and leave the firm at some point and go on to bigger and better things. And the person who gets this memorandum looks at it and thinks, Elena Lopez, I don't know her. I guess she's an attorney because she didn't put paralegal here. And again, the person reading it is going to approach the document in a different way when he or she thinks that it's not is an attorney who prepared it. So that's a reason that it's important to list that. That again, that is to protect you primarily. So keep that in mind. Always have some kind of description of your title here. It's not necessary to have a description to the to person. It's just necessary from the author of the memo. Then, as I said, we're likely to put the date here. Now, why is the date important? Well, it is important because whatever you're preparing may be used time and time again in that law firm, even after the particular matter in litigation or whatever the issue is has long since been resolved and the clients have moved on and done other things. The legal ideas that you have uncovered and that you're describing are timeless, and they still are going to be the law long after the matter is closed. And so very commonly, there will be memoranda files where all of these files are maintained. They're usually keyword searchable, and so other people can research those files. And so what will happen is that, let's say this legal memorandum is something that you've pulled up in the historical files, and it's exactly what you need to know for your client. Well, you'll then look at the date and go, okay, well, we're not in 2011, so I'm going to have to research the law, everything that's come up since since August 6, 2011, and figure out the legal developments. I don't have to look before then, though, assuming that I think Elena Lopez did a good job. I can just update from that point. It can also let the reader know, I might read this and go, oh, well, you know what, this isn't that helpful because a new law came down in 2013. So I'm not really going to focus on this legal memorandum because it's dated. And so it gives that kind of information. So be sure to include the date. I don't think, though, it's necessary to put it up here. Again, I would put it right above the Ray line. You may notice another feature. It's very common for these to all be in caps. It doesn't have to be. Again, your style manual will tell you that. Another thing that's also common is that this will line up. It just looks sharp. It looks nice. It looks professional. And if you don't have it line up, there's a certain level of informality about it, of lack of precision about it. It doesn't create a good impression. Now, you may think to yourself, well, what do I care? Isn't the quality of my ideas what I'm being judged on? Well, in a perfect world, that's how things would happen, but you're making a first impression here. And especially if you don't have a close relationship with Alan, if he sees a memorandum where, you know, Alan is over here and Elena is here and Neely is here, the first impression is going to be, Elena doesn't know how to format a legal memorandum. That's the easy part of writing a legal memorandum. If she can't format it correctly, I doubt she's done anything correct. It's the kind of the first thought that many legal professionals will have, and it's not hard. The way to format from here is just to tab over until it lines up. So be sure to keep that in mind. Now, some firms have different formatting tools. Sometimes they'll have to and from, and then, and of course, you might have multiple tos, and you might have CCs on top of that. So there can be additional information here. So this is just one example. It's a pretty clean way of doing it. Now we have the Ray section. Let's talk about Ray. Ray can have two different meanings. Some people look upon the Ray line as referring to the reference line. It's what the memorandum is referring to or referencing. Other people see Ray as referencing or referring to the Latin word re or race, which means thing. Whichever version you like is great. But whatever it is, it's going to be R-E in a colon. And then you're going to have 1, 2, possibly even more than 2 lines here. And really your Ray line should include at least 2 elements. One element that needs to include is it needs to identify the client. And this may be everything from the style of the case, to the name of the client, to the file number, to the court, the case number from the court. There can be lots of different ways of presenting that information, and you may want to list it multiple ways. And again, that's how it can end up being multiple lines long. But at a minimum, you'll want to have, if it's a matter in litigation, the style of the case and any client identifiers. But that's not all you want. And the other item that you want to have is something that tells the reader what the topic of this particular memorandum is. I will be honest with you, this is not an effectively drafted Ray line. We can see that they have 2 separate files here. One has to do with Rachel Neely as being the client. The other has to do with Rachel and Melanie Neely being the clients. And so that's fine, because you may well have more than one file that you want to have the data regarding. And we know that has to do with emotional distress. But my goodness, that's a pretty broad topic, and I really think that it ought to be narrowed down much more specifically. There ought to be about one line, but it can extend more than one line, that defines the issue. When I read the ray line, I ought to know what the topic of the memorandum is going to be. In this case, in my opinion, the writer has not done at all an effective job in this area. And she's not presented it in a way that makes it very easy for me to see. It is my practice to, on the first line, define the topic, and then on the line below to talk about file information, things like that. Okay, so that's kind of an introduction to the heading. Let's move on to the next portion. We're going to talk about the statement of facts. Now, there is some level, I don't know if controversy is the right word, but some level of dispute about where we ought to put the statement of facts. It has been my practice, probably because the way my first firm did it, was under the heading. You might have a little introduction before your facts, but the first substantive portion is going to be the facts, and then you go into the questions presented and the brief answers. There are some law firms and some individuals who choose to keep the facts until after you've done your brief answers. I wouldn't say that there's a right or wrong answer to that. I think most people kind of either always do it one way or always do another, but I can make arguments for doing it both ways, and I could even imagine a person who might vary the practice. For example, if you have a really brief factual section, you might want to put that on top. If you have a more in-depth facts that you need to present, you might save that so you get immediately to the questions presented and the answers presented. But as I say, in most cases, you're going to want to do it one way or the other. I'm going to talk about it as if we're putting our facts first. I think that's the more common practice, and really, whichever way you do it, I don't think it really affects the content of what you're actually going to put in the facts, just the ordering of the documents or the portions of your document. Okay, so what are the takeaways from your facts? Well, first thing is you're going to want to organize your facts chronologically. Inevitably, it's going to be the case that some facts are more important than others. And so you might be tempted to think, fact number 17 is really, really important. I want to lead with that. I think it's the most interesting or the most crucial. I'm going to talk about that first and then go 1 through 16, then go on 18 through 25. The problem with that is that our brains work chronologically. If our brains see facts presented out of chronological order, unless we're reading very carefully, we are going to try to make that 17th fact be the first fact in the story. And it's going to result in us being really, really confused. And what happens when a legal reader is really, really confused is he tunes out, he gets mad at the writer, or he makes up his own version of events that make sense. It's rarely a good outcome. You may have seen this technique sometimes in novels that have flashbacks. You're going along in the novel and things are contemporaneous, and then somebody thinks back to a memory that happened in years gone by. When that happens, it's usually just a little bit jarring, and it may take you a second to realize what just happened there. That can be an effective tool in a novel, but keep in mind the person reading a novel is reading it for entertainment. It's a different goal that we have here than for legal writing, and so I would say it would be an unusual case where you will want to tinker with the chronological order. I'm not going to say it's never going to happen, but I would certainly say in the first few years of your practice, stick with chronological. And if at some later point you decide to vary that, have a really good reason and make it really, really, really clear what you're doing. Okay, so that's one thing to keep in mind. Follow chronology. Even if your first 16 facts are boring and they seem relatively unimportant, present those facts first. The other big thing about the statement of facts, and this is the more commonly, honestly, the more common problem, is that people will include irrelevant facts. You really want to just use facts that are important to the analysis that you're going to use later on. If your client was wearing a green shirt at the time of a particular incident, but the fact that it was a green shirt isn't really relevant to anything that happens in with the legal issue you're talking about, then leave that fact out. It may be for other issues in the case, the fact that it was a green shirt is really, really important. And so that fact may be really important to the case as a whole, But what we're talking about here is whether that fact is going to help your analysis of the particular discrete issues that you're dealing with. I mean, a particular matter in litigation might have 20 or 30 important legal issues. And so the fact that you're writing a legal memorandum covering one or two or possibly three of these doesn't mean that all the facts that are relevant to your issue are going to be the same facts that are relevant to all the other issues. So focus on the facts that are relevant to your case. A good test for that is to see the facts you actually talk about in your analysis section. If you don't ever talk about that fact in your analysis section, then what is it doing in your statement of facts? A good rule of thumb in my experience is to have about 80% of the facts that you have in your statement of facts appear in your analysis section. Now I'm going to tell you something about the statement of facts. Sometimes legal writers, maybe new legal writers or sloppy or rushed legal writers, sometimes will say, well, I talk about it in the statement of facts. I expect the reader to remember that fact and to be able to do the mental gymnastics to see how there's a connection between that statement of facts section and the analysis I do later on. Well, you're really expecting a lot from your legal writer, and it's not very reasonable to have that kind of level of expectation. You want to connect the dots. You don't want to cause the legal writer to connect the dots. And so you'll need to mention that fact again, and not just mention it, but show how it supports or tends not to support whatever proposition you're talking about. So don't think, oh, I already talked about that, don't talk about it again. If when you're looking through your facts situation, you realize, hey, I never talked about fact 5. I have fact 5 listed in my statement of facts, but I never talk about it in my analysis. But somehow or another you feel hesitant to cut it out. It just seems like something you want to include. What you may want to do is take that fact 5, keep it in your statement of facts, but also talk about it in your analysis section. Because your reluctance to remove it is probably a sign that that fact in some way is influencing, or you think it should influence, the analysis section. So use your statement of facts as an opportunity to beef up your analysis if you find that some facts seem to be in one place but not in the other. Many times people will wait, even though the statement of facts is kind of the lead-in section of the legal memorandum, many times folks will wait and do their statement of facts at the very end. That's actually my preference. I'll write everything up, and then I'll go through and I'll highlight all of my facts that I use in my analysis section. And then I'll gather all those facts together. I'll put them in chronological order. I mean, they won't be in chronological order, obviously, in the analysis section. And then I will, I'll need to put them into complete sentences and tweak the language and do things like that. But for the most part, I'll be probably about 80% of the way to having my statement of facts. And then I might, as I'm polishing it, I might think, oh, why don't I add this fact, or why don't I add that fact? And then I might, every time I'm tempted to add a fact, I might think, should I add that fact to the analysis section? And think about how or why I might want to do that. So let's say I've gathered all of my facts from my analysis section and I'm ready to polish them into my statement of facts. How am I going to actually write that? Well, we want to write objectively. We don't want to stack the deck in this section. Let's say that of your 25 facts that you're going to present, 15 really support analysis point A, and that's the side you've come down. You think A is the right answer to this question. 10, though, tend to support perspective B. You might be inclined to start saying, well, I really think A is the answer, so I'm really going to work hard to persuade the reader to go with A. Again, this is not persuasion. This is about objective writing. You're not stacking the deck at all. So there's no reason to emphasize those 15 good facts and diminish the 15 bad facts. Not at all. You're going to want to present all those. Your goal here is to present your case warts and all, and to show all the strengths and all the weaknesses of it. Now, I said before that you're going to want to have about 80% of your facts in your statement of facts also appear in your analysis section. And that's true. I mean, it may be 100%, but probably at least 80%. So you may be thinking, well, what's the other 20%? Why would I add anything else if I'm not using it in my statement, in my analysis section? Well, sometimes you need just a few facts to transition, to tell a story, because after all, in your statement of facts, you do want to tell a story most of the time, at least a little bit of a story. Our brains are designed to understand and process things in a story format. And one of the things you want your reader to do is to remember the facts and to remember the sequence of facts. And it's a lot easier to remember a sequence of facts if they're presented as if they are a story. So you might find that it's necessary to add a few facts either to make it into a story or to show transition or clarity or to help the reader process the information. So whenever you include something that you're not actually using in your analysis section, stop and think, why am I including it? Is it helping me tell the story? Is it helping me add a little bit of interest so the reader is more engaged? Is it going to help the reader make sense of what's going on? If those things are going on, then it's okay. Again, keeping it to that 20% though. So that's how the statement of facts works. Let me scroll ahead here, and here's an example of a statement of facts. There are some problems with this statement of facts, I'm going to be honest with you. First of all, it's single-spaced, ought to be double-spaced, obviously. That's how we do a legal memoranda. Second of all, it doesn't have any record citations. This is going to vary from firm to firm, but it's a good idea to include record citations. So if you are referencing a particular fact, where'd you get that fact from? Obviously, if you end up filing this anywhere, say as part of a brief in support of a motion, you're going to have a factual citation for all these items. Now, is it a big deal if you don't have it now in your legal memorandum? No, it's probably not a huge issue. Just keep in mind, though, that if you have it, if you're actually looking up the document right now and you're seeing it, why not include the citation? So you don't have to go back and find it again. Okay, so you might want to include citations. Another thing that's problematic about this is its length. This is longer than we probably needed for it to be. You really want your statement of facts to maybe be, I would say, no more than 20% of the overall length of your document. If you get to the 30% area, you're causing me to have some concerns that you're telling more story than you are focusing on the legal analysis. And so I'd say 20 to 30%, but oftentimes it can be as low as 10%. And so this seems a little bit on the long side for that purpose. Let's go back though. Let's go back to where we were. So we've talked about the statement of facts. Now let's talk about questions presented. In some senses, this is the easiest section to write, and in some senses can be a challenging section to write. It's easy in that the attorney may just give it to you. He or she may give you the question exactly the way he or she wants it to be written. And even if he or she doesn't give you that, he or she may give you specific enough guidance that you're going to be able to turn it quickly into your questions presented. There are two ways of doing questions presented. One is my strong preference, and I think it's the more common way to do it, and that is to actually have it in a question format. So you'll actually have a question mark at the end, and it will read like a question. It'll have something like why, or how, or is, those types of words, question words. Another way that you will occasionally see is that instead of actually phrasing it as a question, you will see it begin with the word whether. In this case, it'll be a sentence fragment. This is actually a common way, and it's not, well, it's common because most appellate courts require it to be written this way. It is the way that questions that are prepared for an appellate brief are phrased with the word whether. It's kind of an old-fashioned tool. It's a very formal tool, and it is more difficult for most readers to fully understand and to process the information. So again, if you're writing an appellate brief, you're going to use whether or whatever the local rules say, but for a traditional legal memorandum, most likely you're going to write it in a question format. Now, even though question format is easier for us to process in our brains than a whether format, and by the way, when I say whether, I mean W-H-E-T-H-E-R, not weather as in, is it raining, is it snowing, that kind of weather. Whether as in whether or not, that meaning. So even though question format is easier for us to process than whether format, our brains process sentences, declarative or command sentences, easier than we format questions. That's just the way our brains are, and that's just reality. And so when you're working with the question, it's going to take the reader a split second longer to process the information. On top of that, we want a question that stands on its own. Many times the reader won't read the facts. Even if you lead with the facts, he or she maybe is really in a rush and doesn't have the luxury of reading all those facts. And so our question has to be clear enough so that even if the reader hasn't read the section ahead of it, he or she understands what the issue is. So for example, we don't want an issue that says, will our client win this case? No, because that's only of interest to our client. We want the question to be of the timeless variety, something like this. Given that our client was in the zone of danger at the time that the scale fell on her, is she entitled to recover damages from the person who dropped the package? It needs to include enough facts and phrase the issue broadly enough that the reader can get legal meaning from the question, even if he or she doesn't know the underlying facts, and even if he or she isn't related to the particular case that you're doing this research for. Remember, I said that we're going to be using these legal memorandum many times years in the future, where who cares what happened to those particular clients? I mean, you care right now, of course, but those clients are ancient history by the time maybe this matter is being reviewed in some future date. Another thing that we want to keep in mind when we're writing a question is that we're not being argumentative. And when I say argumentative, I don't mean by this that you're not being unpleasant, but I mean that you're not making an argument. Again, we're being objective here. We're not being persuasive. So being argumentative in this context means you're not trying to persuade. This is a difference between a legal memorandum and one of those briefs that support an appellate, an appeal. Because when you're phrasing those whether questions for the appeal, you are argumentative. You phrase the question in such a way that it's obvious what you think the answer is. When anyone reads that whether question in an effective appellate brief, the reader ought to say, well, of course I know what the answer is, because of the way that you phrased it. Now, of course, you phrase it in a way that stacks the deck on your client's side, but opposing counsel is going to write his own version of the whether question, and he's going to stack the deck so it seems obvious the other answer is what the court ought to decide. So it's a very, I guess you could call it almost, you're putting a lot of spin on it. If you ever watch TV talk shows where people are discussing various political issues, you are being very partisan. You are taking one side or the other side. Obviously, you're not what your political views are necessarily, but what your client's perspective is on this issue. And that's very effective in appellate brief writing, but that's not what we're doing here. We're being objective. So the question as you write it ought to be neutral. You ought to read the question and not have any idea what the correct answer is. And hopefully when you read it, you're like, that's an interesting question. I'm not sure what the answer is. Okay, let's go forward and let's look at some questions. Here's some questions presented. Does Neely have a claim for the negligent infliction of emotional distress as a result of viewing the injuries sustained by her daughter in a car accident caused by Thompson's negligence? This is a good question, because I don't need to know who Neely is. I don't need to know who Thompson is to figure out what the issue is. The issue is, if I see my daughter be in a car accident, that's going to be upsetting, obviously. So would I have a legal claim for negligent infliction of emotional distress under those circumstances? Okay, so this is a good question from a legal perspective. You hear it, you don't have to have read the facts. You are intrigued, and maybe you're thinking to yourself, I don't know the answer to that question. Let's look at the next one. Does Melanie have a claim for the intentional infliction of emotional distress arising out of Thompson's statements to her on April 2, 2011? This is not nearly as good, because we need to know what Thompson said about her on April 2nd, 2011. We aren't really in any position to evaluate. Maybe he said that she had a pretty blue dress on, or maybe he said that she's a lying, stealing, blankety blank. We need to know what the statement is to even have a point of starting to think about whether intentional infliction of emotional distress is appropriate. So if we were to remove Thompson's statement to her on this date and actually say what the statement is or summarize what the statement is, then we might have a good second question. Okay, so let's go back up here. That gives you a flavor of how the questions should be phrased. And now we're going to talk about brief conclusion. This could be phrased, and sometimes people talk about it as being a brief conclusion. Sometimes people will call it brief answers. And here we want to have a succinct or brief answer to the questions presented. So if we have two questions, we'll have two answers. This can be very challenging to write because usually when you dive into the research, you start finding, oh my gosh, this is a complex issue. There's a lot going on here. How can I distill this into 2 or 3 sentences? And you have to take a position. You have to say yes or no. And again, real life is more complicated than that. It's yes, but, or kind of, sort of yes, but not quite yes, all kinds of shades. And so it's easy for people to be tempted to say something like, it depends, or undecided, or can't tell. You don't want to go there, or at least you only want to go there in rare cases. You don't have to say yes, definitely for all time, but you do want to take a fairly clear stance, and then you want to give a very brief explanation as to how you got that stance. Again, you're going to go into much more analysis in the analysis section, but that's going to get you started. Okay, so let's go back and look at our brief. Oh, here we go. Sorry about this. I keep on wanting to hit the wrong button here. Okay, so we have our 2 questions, and you can see we have them numbered 1 and 2. Now we go from 1 down to brief conclusion or brief answer 1, and then we'll have question 2, and we'll have the answer to 2. This is the way that it's done. People don't put the answer immediately below the question. That, for whatever reason, maybe that would be a better way of doing it, but it's just not the way people do it. So let's go back and review the question. Does Neely have a claim for the negligent infliction of emotional distress as a result of viewing the injuries sustained by her daughter in a car accident caused by Thompson's negligence? By the way, before we go on, even though this is a really effective one, I really like it. It's long. Let's just read how many words there are. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31. 31 words. And you know, we've talked about the fact that we ideally don't want to routinely be above 20 words. And it's in question format, which makes it that much more difficult. So when we have to write a question, we'd actually like to be below 20 words. This is putting a fair amount of strain on our reader, but it's kind of unavoidable. You really can't write a questions presented and really include enough stuff in it without being at least 20, maybe even 30 words. But that's something to keep in mind. Again, that's one of the challenges with questions presented. Yes, you want to keep it relatively short. You have to keep it in question format. It's got to be objective. You have to have enough facts so that the reader is intrigued kind of with what the issue is. So there's a lot going on there. Let's look at the answer. Probably not. So you can see that the writer has taken a stance. It's not a definite, though. He's given himself a little wiggle room, which is okay. Probably not. And by the way, this first part doesn't have to be a complete sentence. I would say this is the only part of your document that isn't going to be a complete sentence. But you can get away with not having this complete sentence. If you really want to make it a complete sentence, that's okay too. But I'm not going to count off if your very first part of your answer in your brief conclusion section is a sentence fragment. Probably not. Neely cannot recover under the rule that is currently applied in this jurisdiction. This rule requires the plaintiff be present at the scene when the accident occurs. This is the brief answer. And this is about the right length. We can see that we have a sentence fragment, we'll call that half a sentence, and then 2 complete sentences. I would say that if you are getting into, probably you can have 3.5 sentences, this half, and then 3 more. That's probably about the length, maximum length. If it's a really long, you have pages and pages of analysis, you might be able to go to 4.5 sentences, but 2.5 to 3.5 is probably where you want to be. And if you can do it in 1.5, even better. But you don't want to leave with just probably not, because you're basically saying, not always this is going to be the case. And you have to explain, well, why did you say probably not versus absolutely not? And even if you said absolutely not, you want to defend your answer. Well, where is that answer coming from? So you need at least 1 more sentence. Now, I suppose you could remove probably not and just start with Neely. Neely cannot recover under the rule that is currently applied in this jurisdiction. People like the sentence fragment, though, because it's easy to read and to understand because it's answering this particular question. And again, your goal here is just to have that executive summary. So probably it's best to use that sentence fragment in this context. Let's look at our next question and look at our answer here. Does Melanie have a claim for the intentional infliction of emotional distress arising out of Thompson's statement to her on April 2nd, 2011? Most likely, yes. Again, this is a good answer. It takes a stance. Thompson's conduct toward Melanie appears to have been reckless, outrageous, and extreme, and the direct cause of Melanie's severe emotional distress. Again, we're not told what his conduct was, what he actually said. So again, I'm not overly impressed by this conclusion. If we had included what the statement was up here in our question, though, then this brief answer might be a very effective one. And you can see that it's numbered here, and that points to the fact that there's probably a statute or a case, more likely a case to be honest with you, that has a 3-point test. And it would be appropriate, honestly, to actually cite the case here if you wanted to, but it's okay if you choose not to. So that's how the brief conclusion section is going to be. This is going to be the most commonly read portion, well, these two portions together, of your legal memorandum. People will read this, even people who are too busy to read the rest of the document. So you really do want these two pieces to be able to stand alone. If the person has to read the analysis to understand your brief conclusion, the brief conclusion has failed. If the reader has to have read the facts in order to understand the questions presented, to some extent you failed. Okay, so we have completed these 3 sections of our legal memorandum: the statement of facts, the questions presented, and the brief conclusion. Let's look at, sorry about that, hit the wrong button. True or false? Before the discussion section, the writer will present the particular issues or questions that the memorandum seeks to answer. That is true. We haven't gotten to the discussion section. We're going to get to that next, so this happens before. Obviously, you need to know what you're going to discuss before you can discuss it. Before the discussion section, the writer will briefly but completely answer those questions. Yes, that is also true. Okay, so now we're ready for the discussion and the analysis section. This is the real purpose of legal memorandum. Everything up until this point has in some sense been window dressing. Imagine for a second that you are sitting down to read a book. Everything that we've read up to this point is the preface, the prologue, the table of contents, the dedication. It's not the real event. It's lovely and nice and fine, but it's not what the legal memorandum is about. This section is what the legal memorandum is about. You can have an awesome facts, you can have an awesome questions presented, you can have an awesome brief answers, and if you don't do a good job on the discussion section, you have not had an effective memo. If you nail the discussion section, but your other sections are weak, you're doing great. This is the make it or break it section. Everything else is of much, much less importance. So obviously when you're doing this section, you want to spend most of your time on this section. It's obviously going to be the longest, probably twice as long as the rest of your sections combined, at least as long as your other sections combined. And so you're going to spend most of your time, you're going to spend most of your length on this section. So keep that in mind as you're working. I will tell you that this is for most students the most difficult section to write well. And I think we all know how to tell a story. We all know how to write a question. We all can summarize ourselves pretty well. The other sections are easier to write, maybe more fun to write. Don't fall into that trap. Focus on the discussion section first. Then whatever little time you have left over, do the other parts. Don't fall into the trap of saying, oh, well, I'm intimidated by the discussion section, so I'm really going to rock the facts. I'm really going to rock the questions presented section. You aren't going to get enough points in those sections to make up for having a weak discussion. So focus on the discussion section. Okay, so let's talk about the IRAC method of analysis. As you can see, a little mnemonic. It's kind of like the country of Iraq, except instead of a Q at the end, we have a C. And this stands for issue, rule of law, and the A can stand for either application of law to facts or analysis, whichever you prefer, and conclusion. This is an effective way of organizing your discussion section. It's not the only way, but it is an effective way of doing it. So think about this. If you're thrown and you're not sure what to do, this is a good fallback. It's a good plan to do. If you decide to vary from this, you'll want to think to yourself, well, why am I varying for it? What's the reason for it? In this class, there aren't going to be reasons why you're going to step away from this program. Use this in this class going forward. You're not going to want to use a lot of quotations. This is hard sometimes for students to back away from. Quotations are easy to use. You just cut and paste, you put quotations mark around it, you do the citation, you're good to go. You don't have to write it. It's already been written for you. But there's a few problems with that. The first thing is that judges write in a very stilted, artificial style. And so it's not easy for the reader to understand what's being said. The second thing is that you're taking something kind of out of context and plopping it into your memorandum. It's not going to flow as well. Let's assume for a second it flowed well in the judge's opinion. Maybe it did, maybe it didn't, but let's assume it did. Well, there's just no chance it's going to flow the same way in your document. So it's going to be a little jarring when you stick it in there. The third thing, though, and the most important thing is that you're trying to show how this fits into your view of this particular issue. And so this really requires the personal touch, your analysis, your words. You can certainly put a quote, a snippet in a quote. You can even have a quote or two in it. A good rule of thumb in your discussion section is to not have more than one quote of, say, more than 2 lines on a given page. You might have 2 snippets, but if it goes beyond 2 lines in length, when you add them up, you probably ought not have that. There's a few reasons for this rule of thumb. One is that when you quote, you're going to want to spend a lot of time talking about what that quote means. So don't think, oh, I can quote from the court opinion, that's all I need to do. No. If you take 2 lines from the court opinion, you're going to spend at least probably 6 lines telling the reader, this is what that means. So you're actually giving yourself more work to do. So that's one reason why you need to make sure that you're not putting too many quotes on a page, because that means you're not really analyzing it. And again, the second is we want to do the job for the reader. We want to make the reader's job as easy as possible. So we want to spoon feed the analysis to the reader. And the way to do that is to paraphrase and to take very small quotes. Then, of course, we'll want to use proper citation, Blue Book citation, for both cases and statutes, and we'll talk more about that going forward in the course. So, true or false? IRAC stands for Issue, Rule of Law, Analysis, and Conclusion. That is correct. We could replace analysis with application of law to fact, if you prefer that, but this is the equation, so to speak. IRAC is used for legal memoranda and legal briefing. That is true. Remember we did some case briefing earlier in the semester? Well, that we use the IRAC method for that as well. Legal professionals use a detailed and precise tool to refer to legal resources. This tool is called the Blue Book. That is correct. Of course, in Texas, we have another book that we need to use too, and that is the Green Book, and that's prepared by the University of Texas Law School. It's used by people whether they went to that law school or not. It's an important additional tool that we have to use in Texas, whether we're practicing in Texas state court or the federal court in Texas. And so when I refer to blue booking, usually what I mean is blue booking and green booking. But I may not go ahead and say the green book, but just assume I mean that, unless I tell you for whatever reason, no, I don't mean green book in this particular context. So here's an example of the discussion section. Now this is pretty quirky. I'm going to be honest with you. There's some problems with this. The first one, of course, we've already talked about this, is that it is single spaced. We don't want to do that. That's not a good format. The second is that the writer is advertising or stating where the issue is, where the rule is, where the application is, where the conclusion. I've never seen anyone put it out in the margin like this. It might be okay if this word conclusion here was actually used as a heading and this word application was moved over here and used as a heading. But I think better than actually having these terms would be to actually define what these are. So to say what the rule is, maybe since we have a Roman numeral 1 here, we might have a capital A that states the rule. And then we might have a capital B that talks about how the application of the rule works in this case. And then a section C that gives you a concluding statement as opposed to just saying conclusion. So this structure I wouldn't recommend that you use. Using headings is a really good idea. This one doesn't use as many headings, honestly, as I would like to see. You're going to want at least to have one heading per page. And again, we're talking about double-spaced pages, so there's going to be a lot of headings. And you're going to start, of course, with a Roman numeral 1, And of course, whenever you have a Roman numeral 1, you have to have a Roman numeral 2. You have to have at least 2. You could have a lot more than 2, 3, 4, 5, 6, whatever. And then under Roman numeral 1, we're going to have a capital A. Whenever you have a capital A, you got to have a capital B. You can have more, C, D, and E if you want to. You're going to want to have at least that level, those 2 levels in a legal memorandum. Beyond that, though, after the Roman numeral 1, then you'll have just the so Roman numeral 1, then we'll have the capital letter, then we'll have the normal numbers, 1, 2, 3, 4. And again, if you have a 1, you have to have a 2, and so forth. Then after that, you're going to have the lowercase a, lowercase b, lowercase c. So that gives you a sense. You can get as much granularity as you can. It's generally speaking a good idea to have more headings rather than less headings. Of course, anything can be carried to extremes. If you're finding that you are having a heading for every single paragraph, that's probably a little bit of overkill. Okay, so now we're up for conclusion. The conclusion is a section where you're going to summarize what you've just told in the analysis section. You're also going, oh, by the way, let me go back here and talk one more thing. You can see that in this case, the discussion, this is just an excerpt of the discussion. This is not the whole thing. This is a little bit misleading because you might look at this and go, well, a statement of facts is as long as the discussion. Well, no, this is just an excerpt. For one thing, they're just talking about one of the 2 issues. So at a minimum, the discussion section is twice as long as the statement of facts. But my guess is it probably is maybe 3 or 4 times as long. That would be a much more appropriate relationship there. So don't be thinking that this discussion section should be of a comparable length to the facts. Again, I think probably a 4 to 5 ratio would be more appropriate. Okay, so let's go back to the conclusion. So the conclusion ought to summarize what we've just learned in the discussion section. It ought to summarize the statements that we made here. It's going to not use sentence fragments here, though. And we won't actually use this question and answer format. We'll actually write them out in sentences. So, but it's a different way of stating this information. And then it's a good idea to kind of go, what's the next thing? What now has to happen? So you might have identified areas that need further research. You know, you didn't ask me to look into this, but I think given my research here, we need to look here next. Or you may want to suggest a course of action. I think we ought to file this motion, or I think we ought to oppose that particular motion by the other side. Let's look at the conclusion in this case. Okay, it is unlikely, of course, the first thing to note is that terrible font and single space. Don't like that at all. The next problem we have with this is that they have a 1-sentence paragraph. Unless it's the last sentence in a letter, in legal writing, you should not have 1-sentence paragraphs. Now, I will make an exception for the brief answers. If you have a 1-sentence paragraph there, that's okay. But here, there's just no reason to have that. So, bad form, and bad on their part for writing it this way. Let's read it. It is unlikely that Neely has a cause of action against Thompson for the emotional distress that she suffered due to Thompson's negligence. It is likely that Melanie has a cause of action for the intentional infliction of emotional distress based upon Thompson's outrageous comments to her about her mother. So you can see this is the answer to question 1, and this is the answer to question 2. That's my guess as to why they formatted it this way, but still, I don't think it's a good practice. Note that Neely might pursue on her own behalf a claim for intentional infliction of emotional distress against Thompson for his reckless behavior in taking Melanie from her home and telling Melanie outrageous things. I recommend that we speak with Neely about the effect on her of Thompson's statements to Melanie. This, in my opinion, is a strong claim. I believe we could argue successfully that Thompson intended to injure Neely through this egregious act. So again, this is where we're getting into next steps. We answer the questions again, and then we go into what that answer means for our client. Again, we're really focused on something practical. What are we going to do with this information now that we have it? True or false? Paralegals may not give legal advice to the assigning attorney. Well, hopefully you know the answer to this now. Of course she can or he can. In fact, that's one of the major rules that paralegals have. If you are in a practice and the attorney never asks you to develop legal advice, you are not really functioning as a paralegal. That is an essential part of paralegal. Substantive legal work inherently involves developing legal advice. That is appropriate for you to do. It's almost essential that you do. What's important, though, is that you're sharing it with the attorney directly and that you're not giving it to the client. Okay? Paralegals may not provide legal advice in a legal memorandum that is prepared strictly for in-house use. And again, the answer is, of course, false. When I say in-house use, I mean in-house within the law firm or within the corporation or whatever. It's shared just within the legal department. And again, no, paralegals can and do that routinely. That's an important part of many paralegals' jobs. I hope that this PowerPoint has been helpful for you. Again, you have the ability to review this PowerPoint at any time that you would like to. I'm going to now go to the module section and pull up the other document that I said would be helpful. And that right now I have it in Article on Writing the Memo. I find this a very good document. I think that this writer for the most part is on the money, and I'm just going to kind of go through this and point out things and kind of a few points, share with you my thoughts about this. One thing to keep in mind though, that this document has a bit different audience than the paralegal audience. This is designed for law students who are beginning law school and who are going to be preparing legal memorandum for their professors. And so you'll see some terms along those lines. But really, the answer won't be different for you as a paralegal preparing it for the attorney. Again, the purpose of a legal memorandum is to inform, not persuade. So it's objective. And again, you will represent the client most effectively by being objective and realistic. And again, it's important to remember that lots of different people may read it. There may be people who read it that you don't even work for the firm now and don't know you. And so it's always a good idea to, even though the client is the main focus of what you're writing, keep in mind that people other than the people you're intending might read it. And this can lead to some takeaways for this. For example, let's say you have a particularly close relationship with the attorney. You might be tempted to include a little joke or reference a case. Hey, just like we did this in Bob's case or whatever. It's better to remove anything that's kind of an inside joke or an inside piece of information, because you should assume that any legal professional can pick up your memorandum and really make perfect sense out of it. Another thing that's important to keep in mind is that parts of your memorandum may be incorporated into other documents. Maybe it'll be the complaint, maybe it'll be a motion or a brief in support of a motion. And so it may be necessary at some point to change your document to fit that format. That doesn't really necessarily affect how you write it, but it's good. Maybe you've been assigned to actually write the brief in support of the motion, and you have this legal research memorandum to use as a starting point. Then at least you don't have to reinvent the wheel. And it kind of points to the fact that this document can be an important starting point for lots of different projects. So let's go through the parts of the memo. We already talked about the heading. This is a little quirky what this instructor does. He says the facts are down here, which wouldn't be that unusual, but in his actual example, he puts the facts under the heading before the issue. And here we have, he's acting as if there's just one issue. And that's not unusual. There will be times where there is just one issue. And sometimes the writer of the memo decides whether you're going to have one big issue or several small issues. It is my opinion that especially for new legal memorandum writers, it is better to have several small issues. It's easier to write those questions. And it's easier to write the answers if you're dealing with small pieces. But that's going to turn upon the way that your attorney prefers this to be done, and just kind of how you conceive of the issue. But don't think you can only have one issue or there's some magic number of issues that you're always going to have. It's really going to turn upon the specifics. You can see here the issue also itemizes a few facts that you predict are going to be crucial to the answer. Now let's stop and use word predict. Now that's kind of a funny thing that the author's doing here. You're not really predicting because you're not going to write this, or at least you're not going to finalize this until you've already done your discussion section. So when you say predict, I mean, in some sense you're predicting in that this appears chronological or in page order before you get to the discussion, but you aren't predicting. You know exactly what the important facts are, but you're predicting for the reader, so to speak. The reader should understand the facts without should understand the question without having to refer to the facts. Then we have the brief answer, and this should state the writer's prediction. Again, it's not a prediction, it's just a summary of what you're about to read, and summarizes precisely why it is likely to happen. Some writers begin with the direct response such as yes or probably not. Our book says that they do not prefer this. Again, this is a difference of opinion. I don't have a problem with yes or probably not. So my recommendation for this course would be to do this. This is one area that I disagree with this memo writer. Begin by restating your statement as a declarative sentence, your issue. So the issue starts as a question up here, but you're going to, in your brief answer, restate it with the answer in that section. You'll want to include, again, very briefly, the reasoning, the answer, the why. Facts. And again, we're going to put the facts up here, but you're going to say all the facts that are important, that affect the analysis. And again, the discussion is the largest and most complex part. It proves the conclusion. It proves what your brief answer is. It proves that brief answer. And again, if it's lengthy, and yours will be for this course, you're going to want to break it down into subheadings for sure. Again, this is talking right here in this footnote about a particular form will likely have a particular format, and you'll obviously want to use that. So here's an example of memorandum, and you can see how this is the same setup, having this nice sharp line here. The only difference is that you're, after your name, going to have comma and paralegal. You're going to double space it. We haven't talked about this, but it's not unusual to have a little brief introduction, and you don't even have to say the word introduction above it, although you could. Yeah, let's look for the gray line for a second. You're going to have what's the issue considered. You're going to mention the parties. And again, you may want to mention things like the jurisdiction. If your law firm practices in several states, it may be important to say, hey, this is Texas law, this is Oklahoma law. Then so again, he's starting with the facts. We're going to cite all material facts in chronological order. We didn't talk about this before, but sometimes you may need to list procedural facts as well as substantive facts. So let's say your case is on appeal, or your case is still proceeding through the court system, and it's important to list some procedural facts. Well, the first thing to keep in mind is you're only going to list that fact if it's relevant to the analysis you're doing right now. And of course, a procedural fact will go after the substantive facts because the lawsuit is filed after the facts of the case have developed. Here the writer is suggesting you start with an overview sentence. I think that can be helpful. I would probably put it up here above the facts in that intro section that you may choose to include. But it wouldn't be a bad thing if you were to have an overview, something like this case is about a dog bite or something like that, and then you tell the story. You could do that. You don't want to have more than one sentence, and you don't want it to be a lengthy sentence. Again, you're not putting any legal analysis in your facts section. You will have that in your discussion section. So you're going to use neutral language. You're not going to characterize it. So instead of saying the defendant was speeding through the school zone, you're going to say the defendant was driving 50 miles an hour through the school zone. Well, school zone's typically 20 or maybe 25 miles an hour. You know, it's pretty easy to see that he is speeding, but you might want to say the defendant was was traveling 50 miles per hour through the school zone, which had a posted speed of 20 miles an hour or whatever. You're going to list favorable facts and unfavorable facts, which of course you're only going to list the relevant favorable and unfavorable facts. We're going to phrase it as a question, ending with a question mark. And again, these might be keywords: under, does, what, and those are just some examples. We're not going to use the weather format, so don't worry about that one. Should be, so your question should be precise, should be concise, single sentences. Of course, it's a question. They include relevant facts and general propositions of law. Here's an example of an unsuccessful one. Whether a niece can recover for negligent infliction of emotional distress. I don't think a person's status as a niece is dispositive of whether he or she is, I guess she in this case, would be eligible for a negligent infliction of emotional distress. You need to hear the story. What happened with her relationship with her aunt or uncle that might have caused negligent infliction of emotional distress. So let's see how you might have improved it. And here it's phrased as a weather statement, so we're not actually going to use this particular example, but it gives you a flavor. Whether under Iowa law, a niece who witnesses the aftermath of an automobile accident involving her uncle from a block away can recover for negligent infliction of emotional distress when she observes his severe injuries upon arrival at the scene. Okay, so let's see if we can change it from a weather to a traditional question. Why don't we say, can a niece who witnesses the aftermath of a automobile accident involving her uncle from a block away recover for negligent infliction of emotional distress under Iowa law when she observes his severe injuries upon arrival at the scene? Okay, this is long. Well, how many words do we have here? One, we're going to start with can. So 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, 27, 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, 39. 39, that's pretty high. It's pretty tight, but it's, certainly if there were a way to maybe reduce it a little bit, I might look for ways of reducing it a little bit. Okay, so we have a brief answer. You're going to have your brief thing, yes, no, probably not, use a period, and then you're going to answer the question. And now we have the discussion. This is the heart. You're going to explain the law and explain the facts. This takes a long time. This is going to involve lots of rewrites. You're going to move stuff around all the time. Don't become demoralized when you have your first draft of your discussion. You're like, this is garbage. If you don't have that reaction, you are either Ernest Hemingway, so congratulations, or you are a good and critical analyzer of your work. Everybody's first draft is awful. My first drafts are awful. The only reason that first drafts exist is that you've got to write the first draft before you can get to the fourth and fifth and sixth draft. Don't expect much from your first draft. Don't beat yourself up if it's not very good, because it won't be. You need to be critical about it. You need to diagnose its problems and fix them. But it's not just a good idea just to bleed ink all over the page and not beat yourself up. Don't be constantly editing yourself as you complete it. So have a realistic perspective on the discussion section. Know that you're going to have very little from your first draft in your final draft. This is just a step in the process. It's a little bit like making a cake. When I stir all the ingredients up, it's nothing like my cake when I take it out of the oven. But I got to stir the ingredients in order to have that final cake, even though there's very little connection between those two things. Okay, one thing, let's talk about this one. This is a really common issue, and this is one of my weaknesses when I was first an attorney. The writer here is calling it listing behavior. And kind of what the writer does is let's say he's going to talk about 3 cases. So we'll have 1 paragraph on case 1, 1 paragraph on case 2, 1 paragraph on case 3. And basically you say case 1, and you say what the holding is in case 2, say what the holding is in case 3, and say what the holding is. But you're not connecting them together. You're not saying why these are important. You're not saying how this one relates to this one or which standard is more important or any of that kind of stuff. You need to not fall into that habit. You ought not be devoting single paragraphs to case after case after case. Okay? Don't treat cases independently in that particular way. A good way to approach this is to have roadmaps and thesis statements. Your thesis paragraph is a good idea to have that being your first paragraph in your memorandum. Announce where you're going. What's this journey? I mean, think about it. If let's say I was driving to Houston, what's my roadmap for Houston? Well, I would probably get on 75 and I would go down until it turns to 45, and then I would keep on going south until I hit Houston. That might be my journey. Maybe I might say, if let's say I'm at the Preston Ridge campus, I might start on Wade Boulevard and I might go west onto Preston, and then I go down south on Preston until I hit 121, then I go east on 121, then I go south on 75. That's my roadmap. I tell the reader where I'm taking them, what are the high points on the trip, and then we talk about each one of those points in much more detail. Giving the reader a roadmap is preparing him for that journey. It's really, really useful thing to happen. A really common way of doing a roadmap in this is going to be look at the elements of your particular claim. If you're looking at a case, the case might say, plaintiff has to prove these 4 things. Well, that's awesome. Grab that and run with it. You have been given your roadmap because you now know the 4 sections of your discussion. Your first section is going to be that first element. Your second section is going to be the second element. Your third section is going to be your third element. The fourth section is going to be your fourth element. It's organized itself. That is amazing when that happens. It could also be a statute or some other tool. When you see those lists, go for it. And sometimes the list may not be numbered or with letters. You can just read through and see the division. So don't worry if they don't actually state them as being A, B, C, D, or 1, 2, 3, 4. You can find and pull those things into the order, okay? Keep in mind you're going to be talking about legal rules. You need to spot the legal rules. Again, that's usually going to be your organizing principle. And then you're going to have to relate the rule to your facts. You should never talk about a rule without relating it to the facts. What's a rule in isolation? The reason that you care about the rule is how it affects your client's situation. So connect the dots. One of the sources, or one of the things that I see in so many of the legal memorandum that I see from students is that the student jumps. She's doing a great job. She said A, B, C, and suddenly she's on point Q. She knows it, and it makes perfect sense how you get from C to Q. And she's not wrong. Yes, there is a path from C to Q, and she understands that path. The problem is the reader hasn't been living and breathing this the way that the writer has been living and breathing it. You need to go through all of those steps. When you're writing it, there will be moments that you say, gosh, this is insulting. I'm like, telling them, it's kind of like run, Dick, run. Go ahead. You really aren't going to insult people. Walk through step by step. Talk about all the facts that are important. Not just the 2 main ones, but all the facts that either help you make that point or tend to cause somebody to think maybe that isn't the conclusion that we ought to reach. So every time you talk about a rule, analyze that rule and relate. And when I say analyze, I mean relate it back to the facts and show how those facts relate. Don't just list the facts. Say this fact supports this particular element because or how it does or things along those lines. Then you want to have a concluding paragraph for each. So let's say you had the 4 points, the 4 elements. Well, when you're at the bottom of that element, so you're in one element, you're going to state what the rule is. You're going to talk about all the facts and not just talk about the facts, but show how they relate to that particular rule. And then you're going to have a conclusion. And then you're going to go to the next element. Let's see if there's anything else we need to talk about. So here are some other things to keep in mind. Find the test, the legal tests. Find the statute or the case that identifies the test. And here we have a test. This is going back to the example we had, the niece case. Let's say your case involves a niece, Mary, who witnessed her uncle Jack being injured in a car accident. Well, here's the test that they had in this particular jurisdiction. Whether the bystander was located near the accident, well, we know Mary was a block away. Whether the accident resulted from sensory and contemporaneous observation of the accident as opposed to hearing about it from others after its occurrence. We know Mary actually sensed it by seeing it. Whether the bystander and the victim were closely related. Well, it's niece and nephew. Those are the levels. So what you'll do is you'll go through and you'll have one, Roman numeral 1 probably, about her physical proximity. Now, I don't know whether a block is near or not. You're going to want to look at cases and figure out, well, how have courts defined near? And so you'll talk about the block. Okay, it was block near. Well, there may be one example where the person was only 5 feet away. You could say, well, we weren't that close. Another case where the person was, a quarter of a mile away. Well, we're closer than that. So you want to go through and not just announce, well, the standard is that the bystander be near. In our case, she was a block away. That doesn't answer the question. The answer is, well, is a block away near? And if you think it is, well, why do you think it is? What cases are you using to support that argument? So connect all the dots. And again, if you have more than one issue, your memorandum may have more than one test, and there may be sub-tests under issues. Again, use the test that you have as your outline. Again, if there's 4 elements, you're going to have 4 sections. As you are writing your paragraphs, you're going to want to use those topic sentences. You're going to have these be the elements of your test. The first sentence under each one of those sections is going to be a restatement of that test. And then you're going to support those. You're going to use all those facts and make those connections. And again, not just recite the facts, but show how they support those facts. And of course, you're going to discuss the facts, obviously showing why they support. And then you're going to have a conclusion. You may need to talk about contrary authority. There's different ways of organizing this. You might do it within the same paragraph, within the same 4-point structure. But it may be that there's 2 tests in your jurisdiction, one that's a 4-point test, and another that's a 3-point test. And so you might need to have, Roman numeral 1 is the first point, the first test, then you'll have A, B, C, D, the 4 points of that test. And then you might have Roman numeral 2, the alternative test, and then you'll have points A, B, and C for the 3-point test. So sometimes the structure is going to vary depending upon that. You may want to play around with it. Set it up one way once and then set it up another way, move things around and see what flows. Here's a good checklist here at the end. Be on the lookout for this. Good questions to ask yourself as you're preparing these. Again, you're going to use the chronological organization style. Yeah, and I would say no, even half. Well, if you had 2, I would say if you only have 1 question, then you'll want to definitely keep in the 1/3 or less area. If you have 2 questions, being 1/2 would probably be okay. And again, you have to take a position, not an option not to. So here are just some good tools. I hope that this information has been useful for you. It's been a pleasure spending this time with you. Bring any questions that you have regarding this topic to our class so we can discuss it in more detail as you find appropriate. And again, thank you for your attention.